Initially, when Honorable Breitelbach was raising the matter, I was agreeing with her overwhelmingly. But there's an aspect which I don't agree with. When she wants to project certain people against whom complaints have been laid in this affidavit as a paragon of virtue, he's even citing their experiences and so on. I think that is unfair, and that is being argumentative against the witness before us, because we must be fair to witnesses here. Allow a witness to present, and then when he has presented, you make your arguments. Not to say when a witness has not even opened his mouth, the people that we are complaining about are competent people, they have experience and so on and so forth, as if the witness is hallucinating. That witness is raising these complaints out of frustration. I understand the legal aspects and the legal concerns that Honorable Breitelbach is raising, and I agree with them to say it's going to be prejudicial to the witness when he deals with matters which are before court or which are pending, because even with us, it's going to be difficult to interrogate his testimony, because we will interrogate it with caution. We won't understand to which extent we should go, because we will be trying to save her, and we will be trying to save his right to be innocent to be presumed innocent before he's proven guilty. So, but the problem here, Chair, is that our house is not in order. It goes back, and I'm afraid now that witnesses or members of the public largely are going to be on the receiving end of our demise as the committee. But that demise is orchestrated by the legal team. We raised this thing in one of our meetings, Chair, and we asked a question that, what is it that a witness with the evidence leader do during consultation? What are they doing? If here in this committee we deliberate on issues that are supposed to have been dealt with during that consultation, because they have been employed to do exactly that, to say this evidence by its nature does not belong to a committee. Maybe you must submit a written statement, or maybe you must apply to tender this evidence in camera because of its nature. That guidance is supposed to be tendered during that consultative process. But it does not happen. What are they doing? Maybe Advocate Arenzo needs to tell us. What are they doing during consultation? Are they guiding witnesses on legalities or not? Or they just accept, they just say, no, bring everything, we'll just pass it as it is to the ad hoc committee. So I'm very worried, Chair, in as much as I agree with Honorable Breitelbach that now we want to turn away a witness who has come here under an impression that he's going to get an opportunity to explain his side, and who was going to do otherwise if he was properly guided by the evidence leader. So he has been failed by this committee. He has been failed by the evidence leader. And now we want to suffocate him. We want to turn him away. He has compromised all his schedule to come before this committee and argue for his case. When we're here, I understand, members, because we knock off at night here, so we don't get time to read these statements. I've only read it now when I'm here. And I'm getting concerned as I'm here as to what is it that we're expected to do here when a statement from page 1 until the last page talks about cases which are pending before a court of law. So what are we expected to do as members of this committee? So, Chair, I know we're towards the finishing line. We're at the tail end of this process. But our concern remains very high against the evidence leader and his team on how they conduct this work. They are not doing their job during consultation. That is why sometimes we read 180 pages, which is full of irrelevant content. Because during consultation, they must say, no, this one, Advocate Patlane, when he was here, was told by members that, no, these are labor issues. Those are the issues for which he was supposed to get guidance during consultation. To say, no, this one does not fall within the terms of reference. It must not go to the committee. Because he has been employed to do that. So, Chair, unless the witness before us feels strongly that he wants to continue under the guidance that we have given him, or even after the concerns have been raised about the risk he is imposing himself to, we are saying we're of the view that he must submit rather a submitted statement, I mean a written statement. It's unfair to say he must not submit anything at all, because he's complaining about the judiciary here. So when you say the matter is under a competent judiciary, we are already making a judgment that all the complaints he's raising are invalid, because the institution that he complains about cannot help him if he feels that it is compromised. How can you complain to the same judge that you are complaining about, to the same magistrate that you are complaining about? So let the client not be helpless. Let's not make him vulnerable and say, no, go away with this statement, we can't help you. If he continues to feel strongly that even after this he can continue, it's fine, he can continue. But as this committee, we have been honest to him to say this is prejudicial, but if he wants to continue, can continue, Chair. Thank you.
Honorable Breitenbach,
Chair.
do you want to speak?
Yeah, Chair, just on one point, I didn't mention Shabalala and Lowe to suggest that they're untouchable. I mentioned them to suggest that they have a lot of experience and they will be watching this because it's an opportunity they wouldn't let go by. Not any other reason did I mention them. Yeah.
Okay. The EFF?
And Chair, I remain deeply uncomfortable with the process.
Okay.
I'm not sure that I want to participate.
Sure.
Thank you, Chair. Hey, it's embarrassing. We are an embarrassment to the people that have elected for us to serve here in Parliament, that we can even sit here and while after a witness is even sworn in, that we raise things that should have been resolved a long time ago. I echo my colleague's point of the issue of resources for this committee. I disagree with him that we must put the blame squarely on the evidence leaders. Literally, we have 3 evidence leaders. If you go to that commission, who's pretty much has the same number of witnesses that we are dealing with, they have like a whole team. Our legal team here, our technical team here, they're not here full-time, Chair. And we've been raising this for a very, very, very long time. We even got a letter, or finally the letter was circulated on why we don't even have a forensic investigator. We are an embarrassment to the people who voted for us. Parliament is an embarrassment not to provide adequate resources. And it's got absolutely nothing to do with the fact that we don't have money to be able to serve South Africans with the dignity and the efficiency that we need. It's just embarrassing. And on the merits of what has been raised here, I think it's highly disingenuous to talk about active cases. Pretty much every single person that has come here, senior officials of SAPS, they have active cases. It's not going to be the first time that we've had witnesses, even in committees, where they say, I can't respond to that because it's in court. So to all of a sudden feel uncomfortable participating because someone can be prejudiced is, I don't even know where we're pulling that from. It is something that goes on here. It's even weaponized in this Parliament, even in committees, that we shouldn't ask that question because that question is going to jeopardize the case. We hear that it's a long sing-song story. Mr. Chetty has been here. This is his second time The first time we even sent him away. The fact of the matter, whether this is related directly to our terms of reference or not, it's a bit late. So unfortunately, we're going to have to take his case. There are matters of SAPS that are involved in here, and we are going to hear, because we are the People's Parliament, and there's nothing in here that's not related to SAPS. It might not speak directly to the terms of reference, but we are here. We'll hear from Mr. Chetty if he's going to feel like he's compromising his active cases or not. But the story of that prosecutors or whoever's going to be prosecuting his case are listening and is going to be prejudiced, I don't see how that has any relevance here at all. Everybody comes here and they say, I can't answer that because I have an active case. And we allow it. It happens many, many times. So it's up to Mr. Chetty. We are here. It's our fault here. We've let South Africa down. And Mr. Chetty will make the call. Thank you.
Bangazita.
Thank you, Honorable Chairperson. Yeah, I also do feel that it is unfortunate that we are engaged in such a discussion at this point. In fact, midway through the presentation of the chief evidence by Mr. Chetty, it's something that we should actually have dealt with before he came here. Now that he is here, and there are concerns about incriminating himself on some of the issues, because most of the matters that he is actually presenting here are before court. I don't see how that is different from General Pahlane's cases, for instance, because he also had a string of issues that before court as I speak, and but I don't see any difference between Mr. Chetty's case and that of General Pahlane. So I feel it's up to the witness before us to decide what he wants to do. If he feels strongly that he needs to continue to ventilate his frustrations before this committee, so be it. Thank you.
Honorable Sols. May you switch off Bangazita.
Thank you, Chair. Look, I have many issues with our legal team, and sometimes with how logistics are handled with evidence or witnesses, etc. But today is not one of those days. I feel that this committee is wrong to, one, blame our legal team and the evidence leader. I disagree. And two, I further disagree that Parliament is an embarrassment. And that's not the message we must send to the country. Indeed, we have limited resources, but we must be honest about what has been done with the resources that we have. We have our evidence leader. We asked for a forensic investigator. You wrote to the Speaker Chair. It's not like it was ignored. The Speaker responded. The Speaker said, we have Advocate Umkhize, who has forensic investigating skills, and she was intentionally appointed because she has that skills. And that replacement was because she possesses that skill. So now, with the limited resources we now have someone here with the investigation skills that we require. So we must not make it look like we are not operating properly here. We are doing the best we can. So I disagree with that position. On the evidence leader and the witness before us, when the witness was here the first time, the evidence leaders was prepared to hear him. It is us as the committee who then asked of Mr. Chetty, because he said he realized that in consultation, the brief consultation they had, all of his attachments was not there. Then, Chair, you ruled that that would be unfair, so you gave it days to say, go get all the attachments to be fair, and then you come back. The evidence leaders follows our mandate. They go and they do that. Now they come back after days. They have the attachments. The evidence leader is ready to lead. We now blame the evidence leader for a mandate that we've given. We don't know Mr. Chetty, but we try to treat everyone in the same way. Lastly, in terms of our terms of reference, what are we meant to do? We are meant to hear anybody that says they can help us to get to the truth around infiltration, political interference, and defeating the ends of justice. We must test that. We did not invite Mr. Chetty. Mr. Chetty offered his information. So let him bring the information and let us test whether it helps us with our responsibility here. So I don't feel that the committee is in a bad position here. Number two, on the issue of Mr. Chetty incriminating himself, we must ask Mr. Chetty, we must give him an opportunity to say, and you must pose the question directly to him. Given the risk that you are potentially going to incriminate yourself by what you are going to present to us, we must ask him, are you willing to take that risk to potentially incriminating yourself by the information? If he says yes, that's consent, what must we do? We will then ask him, we will interrogate him. If he goes to jail because we asked him and he's found guilty, he's found guilty. He must go to jail. We won't visit you, Mr. Chetty. We will be glad that we've contributed to whatever the court will find if you are found guilty. But we can't sit here now and try and protect potential things. We must do our jobs. Just make sure, Chair, that we have his consent on record, that with all the information, he's still willing to testify, and then we go ahead.
Thank you.
Thank you, Chair.
Honorable Vessels.
No, thank you very much, Chair. No, I share the concerns, and I've also, as honourable colleague said, I raised the concerns last night. I raised the concerns with regards to other witnesses before as well, and it's always met with, but we should be the parliament of the people and open to everybody. But, Chairperson, we do have a responsibility to protect Parliament from becoming a kangaroo court. I do not agree that it's the choice of Mr. Chetty if he is comfortable to continue or not. We should make that decision because we are at risk of and the problem lies with what the Honourable Souls say. We must test it. If we test the validity of the allegations made by Mr. Chetty, we're going to have a problem. The Honourable Matthys says that he can exercise his right to say, but this matter I won't respond to, it's in front of the court. Then we can just as well stand up now and leave, because everything that is alleged is in court, because even the allegations made are now in front of IPIT. And the witness already attested to that now and said that his allegations with regards to the alleged wrongdoing in terms of these cases are now investigated by IPIT. So we are in a peculiar situation where the relevance of this is also, it's really not relevant to our investigation currently. What is relevant, we can take note of, as other colleagues said, in the statement. Mr. Chetty is here, he confirmed that this is his statement. Let's take note thereof. Let's protect the integrity of this committee, but also of Parliament. And if we are going to go ahead, Chairperson, I'm very uncomfortable to participate, but Mr. Chetty must then also know that we are also in possession of an affidavit by Brigadier, he's now Mr. Raman Jalam, who is in prison currently, who's a co-accused in many of these cases. We have that affidavit. If we're going to test the validity of the wrongdoing, we can't do that without exploring also the counter allegations and the evidence that's also provided that says it's the contrary. And then we are exactly where the Honourable Breitenbach said we are going. And we are not a court of law. These cases are in the court of law. Let the court of law decide what is wrong, who's guilty, and who's not guilty. Thank you, Chair.
Good morning, Honorable James. And
Hi, good morning, Chair. Finally. I strongly agree. We had this discussion, like Honorable Vessel said, we had this discussion later last night when we left. And I think it's just shocking right now. I always look at matters and I put myself out there and I think, what would South Africans be saying right now about us? I think that's almost the most important things that comes to mind. These people have brought a witness before them twice. And today they start off proceedings by debating whether he should be here or not. That is a disgrace. That is an embarrassment. I think the evidence leader have been subjected to this, to his statement, and I think they should have guided and advised this committee on the best way forward. I genuinely believe, Mr. Chetty, that you will compromise your cases if you proceed here today. And therefore, I also state that as Action SA, we're also a little bit uncomfortable with proceeding. Thank you.
okay. Before I give the evidence leaders and Mr. Chetty to make statements, let me say this, that I understand that when you are members of Parliament, you are politicians, and Parliament is a political institution. And today we want to discuss a procedural matter, and a procedural matter which is clouded by politics. Number one, who brought Mr. Chetty here? Mr. Chetty was brought here by the committee. It's a decision of the committee, Mr. Chetty, that you must be here. And there is nobody who is going to pass the bag and want to blame the committee secretariat or evidence leader. The committee in its own meeting took a conscious decision. Ramano was there, gave us a report. So we must take responsibility, honorable members. I always tell you when I'm here that the chairperson speaks the decisions of the committee. And if you listen to the summary that Honorable Sols gives here, Honorable Sols has given you the whole summary of what the committee has done. This committee further, Honorable Sols has said that the public submission evidences will not be led by statements which they would have prepared with the witnesses, but the witnesses will bring their own statements here. The public submission witnesses. Mr. Chetty has brought his statement. Why do you want to hold evidence leaders responsible for a statement that you said public submission witnesses must bring their statements before the committee. He brought his statement. And so what the committee has to do is to look for the needle in the haystack, separate chaff from grain. If you know what your terms of reference are, go through this whole statement and then look for what is relevant to your terms of reference than to prejudice the witness, either through the committee process or through any legal process. We run an oath every day here, and the honorable members are the ones who must know the oath more than the witnesses. Because the oath here says that any information or evidence or document that the witness presents before the committee cannot be used against him anywhere outside the House of Parliament or a committee of Parliament, unless in proceedings of perjury. Because when he's here, he's protected by the same provisions of the Act that we read to him. That's what it is saying, the oath that we take here. Unless if I'm giving it a different interpretation. But what is being said here is that the information cannot be used anywhere outside Parliament or... So, but the long and short of it, honorable members, is that this man did not come here, this witness did not come here by his own accord. He is a decision of the committee, and the Secretariat has even reported before us. You know what happened? When they reported that the person who made a submission before the committee cannot be found, it was this committee which gave the Secretariat details to say, go and call these people. These are their details. And they went there and did exactly what you have instructed them. It was this committee, it was nobody, it was not a member of the Secretariat or the evidence, it was the committee that presented contact numbers, digits one by one, in a committee meeting to say, call them. And they went out and called Mr. Chetty, he came. He's here now. So there is no way we are going to be temerarious here and try to gerrymander our rules. We are going to proceed with Mr. Chetty, let him present what he wants to present before us. And after he has presented, if you decide to keep quiet, and I will release him to leave and go back home. Thank you so much. We are going to proceed, no further discussions on this matter. Can we proceed, Advocate Arendse?
Thank you, Honourable Chair. I suppose that's the end of that discussion. I can't say anything further as the evidence leader about the process that brings witnesses before this Honourable Committee.
Don't comment on that. The Chair has,
Thank you.
has made a political statement. I don't want to put you on the crossfire. Honourable Sangweni.
Thank you, Chair. I also don't want to get caught in the political crossfire. Chair, can I ask, so we don't have this issue tomorrow? We're having 3 public participation witnesses. If my memory serves, there had been an issue that I'm not sure is Nicolette Ms. Prinsloo had raised about some of these witnesses, including Mr. Chetty and one witness that we are meant to see tomorrow. Can we request that before we maybe even break for lunch, that the Secretariat advises us on the witnesses of tomorrow and if indeed those witnesses should be? Because we had been advised against, Chair. Thank you very much.
Yeah, no, those witnesses are coming tomorrow. They are a decision of the committee, honourable members. Whether they come here to say anything or to say nothing, the committee has said they must come. So we are not going to change our decision at the 11th hour. We unless that they are unavailable, but any of those witnesses who is available for tomorrow, they are going to come here. Honourable Vessels.
Thank you, Chairperson. I just think it's important that we just remember that when the committee decides on the witnesses, we don't have the details, the statements, and the actual detail of what the case pertains to and what the witness is going to present to us. We raised the issue last week on when we received the statements of tomorrow's public participant witnesses. We raised the issue and we said we must look at that, and the legal team must look at that because it does not seem relevant. And I repeat that, Chairperson, that I think we should, I support the Honourable Sangoni because they should look at that before those witnesses travel. And Chair, the same with this. I do not accept, with due respect, your statement that we decided. We did not have all the facts when we took that decision. When we get the facts, we can revise a decision.
Yeah.
Thank you, Chair.
No, I hear you, but what is important, honourable members, you did not only decide. You decided and further instructed the evidence leaders that the public submission witnesses must bring their own statements here. Yes, maybe what we should be saying is that we could have said that let them look at those statements and advise the committee. But you said that no, they must bring what the evidence leaders do. They study the statement of the witness and look at how they can arrange it thematically. But without changing the whole statement or saying this must not go before the committee. So you can't want to apportion a blame on them for doing what the committee has instructed them to go and do. Honourable Nomval.
No, thanks, Chair. I hear your ruling on the matter. I disagree with you vehemently. We agree on witnesses, not on statements. We don't consult with witnesses. Witnesses consult with the evidence leader, and for a purpose. They don't consult with us. So it's wrong for us to be blamed for the work of the evidence leader. I still insist that the content of the statement, a person who can guide the contents, is the evidence leader. If it's not him, then who? Because by saying, Chair, witnesses can, public participation can bring their own statements to the committee. We are not giving an open-ended directive. That must be within the terms of reference, and because it means tomorrow we're going to wake up with a Bible here. A person who decides to submit a Bible to the committee and say, no, it's you committee members who said public participation can submit anything. No, there is guidance that must be provided by the evidence leader. I still insist you can defend him if you like, but I still insist, Chairperson, that the reason why we have the advocate here is for quality assurance. He must exercise his responsibility to say, this is relevant, this is not relevant, this is within the terms of reference, this is outside the terms of reference, not us. Because if you are putting the blame on the committee, then allow the committee to consult with witnesses on their statements before they appear here. We get statements here in the morning. So we give a go-ahead under an impression that further work will be done on the nitty-gritties by the evidence leader, not by the committee. It was going to be a different case, Chair, if when we make a determination, we make a determination with a statement of a witness at our disposal to say, if they can submit statements to us and say, this is what the statements want to present, then take a decision of whether he must come or not. Then we can be blamed for the content of the statement. But we make a decision on the basis of what has been presented to us by the evidence leader, because when they present, they say, no, this witness wants to come and testify on A, B, C, D, and E. Then we say, no, it's fine, we can go ahead. But there is no statement at our disposal. So I disagree, Chair. That is our strong view. But if there is an appetite of defending the evidence leader, then that's not my baby. It's fine. Thank you.
Let's